All right, I'm going to call the meeting of the Sentencing Guidelines Commission to order. Today is June 5th, 2025. Welcome, everyone. Good afternoon. And I will ask our director, Nate Wrights, to take the roll.
Chair. Roll call. Vice Chair Larkin.
Present.
Larkin present. Commissioner Fraze. Commissioner Fraze absent. Commissioner Keefe. Excuse me just a moment. Commissioner Keefe present. Commissioner Knudsen.
Present.
Commissioner Knudsen present. Commissioner Ladd.
Present.
Commissioner Ladd present. Commissioner Mazzaros. Commissioner Mazzaros present. Commissioner Mazzaros absent. Commissioner Middlebrook.
Present.
Commissioner Middlebrook present. Commissioner Moore.
Present.
Moore present. Commissioner Moran. Commissioner Moran absent. Commissioner Mueller. Commissioner Mueller absent. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena. Commissioner Saxena absent. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 8 members present, 5 members absent.
And with that, we do have a quorum. First item on the agenda is adoption of the draft meeting agenda. So I would entertain a motion to approve the agenda. Commissioner Middlebrook makes the motion. Commissioner Larkin seconds. Any discussion on the motion? Hearing none, we'll take a vote on that.
To the motion to adopt the agenda, Larkin?
Yes.
Larkin, yes. Fraze? Fraze absent. Keefe? Keefe, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Mazzaros? Mazzaros absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller? Mueller absent. Reeves?
Yes.
Reeves, yes. Saxena? Saxena absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved. Next is approval of the draft meeting minutes from May 8th, 2025. You should have all received them a week ago. I would entertain a motion to approve the minutes, adopt the minutes, or
So moved.
approve them, whatever it is. Approve them.
Second.
Who did the first? Oh, Commissioner Reeves made the motion. Thank you. And Commissioner Knudsen seconds. Any discussion on the motion? Hearing none, we'll take a vote on that.
To the Reeves motion to approve the May 8th, 2025 meeting minutes, Larkin?
Yes.
Larkin, yes. Fraze? Fraze absent. Keefe?
Yes.
Keefe, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Mazzaros? Mazzaros absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller? Mueller absent. Reeves?
Yes.
Reeves, yes. Saxena? Saxena absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved. Next item on the agenda is sentencing guidelines changes related to the 2025 regular session. I'm going to hand it over to Director Wrights when it's ready.
Thank you, Madam Chair. So it was an eventful regular session after all. You may, watching the news, get the impression that that much was left undone, and that may be true, but in the area of public safety, the public safety bill was enacted, got across the finish line and was signed into law by the governor. I will say that after our last meeting, I did write up the recommendations that you had and sent them to the conference committee that night. And I was told within minutes that it was considered by the members of the conference committee. And I believe it made an impact on the ultimate product. So I just want to let you know that your recommendations do carry weight at the Capitol. So we have today, so the we have today some decisions to make, particularly with respect to ranking new and amended crimes, but also other changes with respect to modifying the sentencing guidelines. These are all preliminary decisions. These decisions will then go before a public hearing in late July and then a second meeting. So you have a public hearing and a meeting, both in late July. And those on different dates. The public hearing is where you hear from the public regarding the changes that you adopt at this time. And the meetings where you'll take final action on those changes. And then the changes will be published in the August 1st, 2025 edition of the sentencing guidelines. And that is our traditional annual date.
Before you go on, I just want to recognize that Commissioner Saxena and Commissioner Fraze have joined us now as well.
Thank you, Madam Chair. So I'm not going to spend a lot of time talking about assigning severity level rankings in general. That's on page 2 of document number 4 rather. And the reason for that is we've been doing a lot of work with ranking offenses lately, and we can certainly pause on that if you like, but I'm going to proceed with some alacrity here, and I'll be happy to slow down at the will of the commission. So the first new offense, so we have 2 brand new crimes that did not exist before, and the additional decision for the commission in such cases is to determine whether the offense should be ranked, and if so, at what severity level. Staff does have suggestions for rankings, and these suggestions may reflect the assumptions that we made when we did a fiscal note on these bills. Because the ranking ultimately affects the number of prison beds that the bill will cost. And but nevertheless, staff's assumptions and recommendations are, of course, not binding on the commission. You are free to establish whatever rankings you wish. The first crime,
Do you want to share that?
Sure.
I guess not sharing it there.
So the first crime, let's see here. The first crime is it's an interesting crime. It's almost like a hybrid of 2 crimes. One of the crimes is the crime of an order for protection, which is a crime involving somebody who feels the need for protection from a domestic partner or other family member. And that the person can then file for an order for protection. There's a long process and statute for that. This process really mirrors that process. It's clear that this law was modeled after the order for protection law, and it's even called an order for protection. But it's not against a family member. It's against it's the order for protection is by a vulnerable adult or somebody on behalf of the vulnerable adult to protect the person from financially exploiting the vulnerable adult. And just like the order for protection, there are criminal penalties for violating the order for protection. It's a misdemeanor for the first time it's committed. Subsequent conviction within 10 years is a gross misdemeanor. And if you have 2 prior convictions under this section within 10 years, or it could be any combination of prior convictions under this section or under Minnesota Statute 609-2335, which is the crime of financial exploitation of a vulnerable adult, then this will be a felony. In our fiscal note, we assume that this crime is not likely to happen very frequently. And the reason for that is a person who has been subject to a violation of this type of financial exploitation protective order benefiting a vulnerable adult who's already been convicted 2 times previously of violating such an order or of violating the crime of financial exploitation of a vulnerable adult is probably not going to be let anywhere near a vulnerable adult's finances. So it seems unlikely to us that this is going to arise to the level of a felony very frequently. And one of the considerations for deciding whether to rank something is whether it happens very frequently. But having said that, there's nothing preventing the commission from ranking a crime that even if it does anticipate that it's going to happen quite infrequently. As I stated, the long-term fiscal impact that we estimated was negligible, based on really the considerable amount of impediments that there are to getting to the felony level. So we did have a recommendation of ranking this at severity level 4. And the reason for that is it's kind of, so severity level 4 coincidentally matches up with felony level orders for protection. And it also matches up with the crime of financial exploitation of a vulnerable adult of $5,000 or less. So it's kind of the entry level financial exploitation of a vulnerable adult. So it's, it seems, because it's sort of like both of those offenses, it made sense to us to rank this at a severity level 4. So that's why we're recommending it. It's not really any more complicated than that. And we do have the reference, the changes to the sentencing guidelines shown below, pretty much just to the offense severity reference table and severity level lists. So any questions on this, Madam Chair? And I don't know whether you want to take these up one at a time or take them up as a group, but.
Yeah, just for the commission's knowledge, I was thinking we could maybe have Nate go through sections A, B, and C separately, and then we could, at the end of each of those sections, consider a vote because they're similar actions. So A is there's 2 crimes here to consider ranking. We can break them out if you want to, but if you don't want to, we could hear what both of them are and then decide if we have a single motion that might cover them both. But first, if there's questions right now about this one, go for it.
So-
Commissioner Larkin.
Severity level 4 is a year and a day, state, 0 criminal history point.
Thank you, Chair. I should have brought up the.
Well, that's
sentencing
what I think.
I thought it was higher. I thought it was higher.
It's 12 months. Okay.
Oh.
So this is the sentencing guidelines
Oh,
grid.
it is,
So
yeah.
it is a year stayed at 0 criminal history score. It's not until we get up to criminal history score 4 that it becomes a presumptive commit of 24 months and maxes out at 30 months. Non-residential burglary is the example offense in there. It's also assault in the 3rd degree resulting in substantial bodily harm. Actually, a number of other offenses that we'll be talking about in offense group 3 are also ranked at severity level 4.
Any other questions on this one?
Seems to make sense. I mean, it's consistent.
Yeah,
It's,
Commissioner Larkin.
so it's 3rd and 10 years.
Correct.
I might feel that seems high if this were a first time, but 3rd and 10, that seems where it should be.
Yeah, I had the same reaction when I was reading the materials and then realized it wasn't the first time. Yeah.
The second offense under 2 is, so I should have said at the beginning that the materials that we're working off of are dated June 2nd. It's an update from June 2nd. So if you're looking at the original meeting materials that Jill sent out to you while I was on vacation last week, you're looking at the wrong edition of item number 4. The June 2nd one is different in that it has this second offense that under section A, and that's this new anti-kickback offense, unauthorized human services remuneration. So this deals with it's got to be related to a healthcare, a publicly funded healthcare or behavioral healthcare program, or a publicly funded childcare program. And the criminal acts include soliciting, receiving, offering, or providing illegal remuneration, which is constituted by money, a discount, a credit, a waiver, a rebate, a good, service, employment, or anything else of value in return for doing or to induce either a referral for furnishing or arranging for the furnishing of something covered under such a program, or buying something of value under the program, or receiving a service under the program. So that would become a crime under this bill. There is a similar federal crime, but there isn't a state crime for anti-kickback, where there's no government funds being stolen, but government funds are basically being sort of diverted from their intended recipient through use of a kickback. There are 3 felony tiers here. These are familiar felony tiers. These are basically identical to the theft tiers. There's a 5-year, $10,000 maximum penalty if the kickback is $5,000 or less. That is the felony theft threshold. There are some smaller dollar value misdemeanor and gross misdemeanor offenses under the theft statute. This crime does not have misdemeanor or gross misdemeanor offenses, so the lowest tier is a felony tier, which is consistent with some forms of theft, such as theft of public funds. So that's the first tier. The second tier, also familiar to those familiar with the theft offense, is a $10,000. 10-year, $20,000 maximum penalty if the kickback is over $5,000 but below $35,000. And then there is a third tier, which also exists in the felony theft statute, but it's limited to particular itemized types of theft. But this offense does apply to the third tier. So it has the over $35,000 third tier. Typically, we'll get to how the guidelines rank that, but all 3 of these tiers are not strangers to us. They are familiar from the theft offense statute. There's also a related change, which I think we need to keep in mind, especially when ranking this offense. And that is that the same bill that creates this new crime also amends an existing crime, wrongfully obtaining public assistance, which is the guidelines don't really consistently refer to this crime. Sometimes it's called wrongfully obtaining assistance. Sometimes it's called welfare fraud. But this crime is amended to include violating this new crime. So basically, if you violate the new crime, you're kind of simultaneously violating 2 different crimes at the same time. You could either be charged, it's really a prosecutor's choice, I think, is how I see it. The prosecutor can either charge the defendant under the new 609-542 or charge the defendant under the existing 256.98. The wrinkle being that there is no $35,000 threshold for the existing welfare fraud crime. So I think it's pretty clear that the prosecutor would probably choose to charge this under, if there was a kickback crime, they'd probably charge it under 609-542 to take advantage of the over $35,000 threshold if that applied. Otherwise, presumably the prosecutor could make a choice, assuming you rank them the same. I mean, if you rank them differently, that could cause a wrinkle that might also influence the prosecutor's choice. But our staff recommendation is not to rank them any differently, but to assign the same severity levels to the lower 2 tiers. So the under 5,000 and the 5,000 to 35,000, we're recommending be ranked at severity level 2 and severity level 3, respectively. And but then there's the third tier, and the third punishment tier is typically ranked at severity level 6, although there is a higher ranking, I believe, for financial exploitation of a vulnerable adult, if I'm not mistaken. But the typical ranking for over 35,000 is severity level 6. So again, staff having sort of this status quo bias, we're recommending ranking at severity level 2, severity level 3, and severity level 6 for the 3 different tiers in increasing severity. And Madam Chair, Commissioner Saxena raised his hand.
Oh, Commissioner Saxena. Commissioner Saxena, did you have a question or a comment?
Seems to be muted.
Yes, I do. Sorry, I had trouble getting off the chair. So yeah, I have a question. I guess and I will maybe I should preface this by saying I do a fair amount of work in this area and clients in prosecutions involving.
Can you hang on one sec? We're like really having trouble hearing you. I want to see if we can get the room turned up. If it's okay, try again. Try talking again, please.
Can you hear me better now?
Yes.
Yeah.
Okay,
Yeah.
sorry, that was my second tech mistake. So I was just saying I should preface my question by saying that I regularly represent clients in cases involving charges of Medicaid fraud that are typically brought by the AG's office. And I think that this new statute is very interesting for a number of reasons. The primary one being that as I read it, and I think this is how the executive director and staff read it as well, the dollar amount is tied to the amount of the remuneration or kickback, which is normally not the way that this type of a statute is criminalized in any other jurisdiction. Usually the loss amount is the amount of Medicaid funds that have been defrauded from the government. And so the kickback could be very small in value, but it could result in a really significant theft from the government. And I may be reading it wrong. This is how I read your primer on it. The executive director writes, and this is how I read the language of the statute. It does seem to be tied to the amount of the kickback. And so even though I guess as a defense lawyer, I'd be happy for this to be the way in which we determine the severity level. It doesn't really comport with the statutes that are used to prosecute Medicaid fraud in the state of Minnesota. And so I don't know what the resolution of that should be, but the idea that one might have to pay a $35,000 kickback to garner the highest severity level doesn't make a lot of sense. To me, it should be based on the loss amount. So I just thought I'd throw that out there, and it's entirely possible I'm missing something.
Commissioner Knutson.
I don't think he's missing anything. I think that's exactly how it reads. But I don't know what we do about that.
Yeah, I mean, it seems like it's been written as this individual benefited by this much for the whatever fraud they committed, right? As opposed to this is representative of what might have been stolen or, directed to the wrong place fraudulently. Yeah, I don't know if there's anything in the statute that we can hinge it on differently.
Except move the decimal point to the left. I don't know.
Can't do that.
I mean, I guess I would just say that if there is fraud of a higher dollar value, that could be prosecuted under the welfare fraud statute.
Okay, well, I want to make sure, first of all, that I was understanding it correctly. And so I appreciate that there's a consensus on what this means. And I just thought I would throw that out there that potentially, a $5,000 kickback could be supporting a much larger fraud. But I take your point. I guess the prosecutor would not just charge this on its own.
Or is there anything that you wanted to recommend differently from the staff recommendation? That's the other question.
Well, I just thought I don't know exactly how to put it, but I don't know that given the way that this is written, the severity level that you could analogize to on one of the theft statutes is right. Or in other words, I'm not sure it's right to compare this to a theft. It might be more analogous to compare it to bribery as opposed to theft, because bribery, the severity level is based on the amount received, as opposed to theft, which is based on the amount that is stolen.
Director Wrights?
Madam Chair, I have a clarifying question for Commissioner Saxena. And that is the reverse also possible, though? Is it possible to have a fraud-free kickback? You know, where if you use my childcare center, I will give you sort of a bonus, which I think would qualify as a kickback under the, but there's really no fraud in the sense that the government funds are being used to fund the childcare center that I'm running, and I'm providing childcare. So I don't know if there's really fraud, but there still would be a kickback.
Well, this is, as Commissioner Middlebrook might know, this is the subject of a few appeals currently. I think that the AG's office would take the position that it is a fraud anytime that a person receives a kickback, whether the service is provided or not. But it's an interesting question. And as I'm trying to not wear my defense lawyer cap when I say this, but it is an argument that we raise many times on the defense side, that violations of program rules and other statutes do not immediately make create a fraud. In other words, if you provide the services, that's not a fraud. So I think that's a more complicated question that you're asking. But I don't think that saying $5,000 $5,000 of a kickback is equivalent to $5,000 worth of theft.
How is bribery ranked?
That's a good question.
I think it's a 4, if I saw it
A
correctly.
4?
Yes, that's true.
Is it always a 4 no matter what the amount?
Well, there's a severity level 2 for contests, apparently. But normally it's severity level 4.
And underneath that, though, there's 3 different kinds of bribery, and there's severity level 4 with different penalties.
Yeah, actually 3 different kinds.
Yeah, 3.
Or 4, actually.
Oh,
So
okay,
there's,
I agree.
6942, 90.41, 609.86, 211B.13.
Oh, yeah, that one too, yep.
We had to write a press release.
That's interesting.
Fighting for you.
I don't know what to do with that. Just, I don't know if anybody else has ideas or if we want to, we have a couple of items on the agenda that are being led by other people, and we could also give you a couple of minutes to think during those agenda items. If there is like anything that struck your mind, I don't know. Or
Well, Madam Chair,
Commissioner Knudsen.
I don't know what we do with this.
Yeah.
We're given language that the legislature passes, and then we're stuck trying to interpret what they intended, and I think we're all reading it the same. And it is what it is. I think the recommendations of staff, given the language as it exists, makes sense. But I think obviously there's a lot of concerns about what did the legislature intend, and what does that dollar amount represent, and why isn't it more akin to bribery versus theft? And those are all questions for the legislature to answer and fix or change as they see fit. I don't know that this statute accomplishes what they think or thought it was going to accomplish. but
But you're comfortable with the recommendations?
I am, yeah.
Okay, Commissioner Moore.
Madam Chair, a vote to support this recommendation would send this to a public hearing.
Yep.
Where presumably more discussion could occur and maybe amendments, if appropriate, voted on.
Yeah, for sure.
So
That's
I-
a very good point.
No, I didn't.
Okay.
Yeah, very good point.
I mean, I kind of echo what Commissioner Knudsen is saying. I think, obviously it's our job to put it someplace and it, it's it's the world those of us that do appellate law live in. Let's just say
Yeah.
that we get to determine what the legislature meant. Or try to.
Giving you a job. Commissioner Keith.
We vote on it, but then note that we had this discussion so that when it does move forward to a public hearing, that is just something that they're aware of.
It would definitely be in the minutes. And so one way we could go is, we had 2 items that we were asked to rank in section A. I didn't hear any objections to the staff recommendations on the first item. We have the second one. It sounds like people might be leaning towards staff. So one motion option is to adopt staff recommendations in part A, subject to a public hearing, send it forward to a public hearing. The other option is to break them out if we want to vote separately. Commissioner Larkin.
I would move to adopt staff's recommendation for both parts of Part A, subject to public hearing.
All right, we have a motion. Do we have a second?
Second.
Second from Commissioner Moore. Oh, you got in there too. Next one. Is there any discussion on that motion? Commissioner
Madam Chair,
Saxena?
I just wanted to quickly note that I appreciate the comments and I will go ahead and vote for the staff recommendation despite my speculation about bribery.
No pun intended, I'm sure. All right, any other discussion? All right, hearing none, we'll go ahead and vote on that motion.
To the Larkin motion to adopt the staff recommendations in part A of the document number 4 in the meeting materials. Larkin?
Yes.
Larkin, yes. Phrase?
Yes.
Phrase, yes. Keefe?
Yes.
Keefe, yes. Knudsen?
Yes,
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Mazzaros? Mazzaros, absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran, absent. Mueller? Mueller, absent. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes,
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
and with that, the motion passes. So we'll move on to Part B. These are a bit more technical in nature. And once again, I'll ask Director Wrights to go through all of the changes in Part B. And with the goal of looking for one motion at the end of that. But if there's anything that anyone wants to break out separately, just give the word and we will vote separately on that item.
Thank you, Madam Chair. Part B deals with amended crimes rather than new crimes. And no rankings are proposed by the staff, but simply making conforming changes to the sentencing guidelines in each case. So each of these does require, in staff's opinion, a change to the sentencing guidelines, but only in the nature of conforming changes. So the first is there's a crime that exists right now involving methamphetamine that involves exposure to children and vulnerable adults. The bill, the act changes that to include fentanyl exposure to children. So doesn't include vulnerable adults in there, but does include children. We're assuming that the commission would like to treat the crime the same as the existing crime with respect to methamphetamine exposure to children. The first instance has to do, it's a little bit in the weeds, kind of diving into the deep end here, but it has to do with Hernandizing and the exception to Hernandizing which has to do with single course of conduct, multiple sentences. When the statute permits multiple sentences for a single course of conduct, the sentence for the earlier offense does not increase the criminal history score for the later offense. I should say that there are a number of statutes that allow for a single course of conduct, multiple sentences, but these are the three statutes that the commission chose to accept from the Hernandezing rule. And there's a comment that talks about the fact that the commission was intentional in only including these three statutes in the exception to the Hernandezing rule. So we would, assuming that the commission wishes to continue that policy with respect to the fentanyl related crime, we make a change in the comment to the description of that offense. And then the main event really is in section 5A, where we change the name of the crime to methamphetamine and fentanyl crimes involving children and vulnerable adults. There's a little bit of imprecision there because fentanyl does not apply to vulnerable adults, but overall the gist of the offense, I think, is correct. Same thing in section 5B, which is really the same list, just listed in statutory order rather than severity level order. So that's the end of 1. Any questions on 1, the fentanyl crime involving children exposure? All right. Moving on then, there's a new consecutive sentence for assaults on sheriff or sheriff's deputy in jail. So there's an existing 609-2232 which requires consecutive sentences for assaults committed by state prison inmates. That's referred to in the guidelines. The amendment adds a second provision there, I think a second subdivision, and that is that if an inmate in a local correctional facility, so that's the existing provision has to do with state inmates, but if an inmate in a local correctional facility assaults a county sheriff or sheriff's deputy, then that's basically assault 1 through 4, then it has to run consecutively. And it's a little bit more complicated because it's necessarily true that an inmate in a prison is serving a felony sentence, but an inmate in a jail may not be, or they may not even be sentenced yet, or who knows. So they have to deal with those situations. But basically, it's the same gist, that the offense has to be consecutive. So we do have a presumptive consecutive sentencing policy. And the recommendation here is under well, first of all, the first change is in section 2C3, which has to do with different statutes that change the presumptive sentence, typically that change the disposition, and the presumptive disposition here is commit to the Commissioner of Corrections under the new law as existing law. So we simply add this qualification, or assault against a county sheriff's or sheriff's deputy. And that's on page 11. And then farther on down on page 11, under presumptive consecutive sentences, we add if an inmate of local correctional facility assaults a county sheriff or sheriff's deputy as a presumptive consecutive sentence, which is what the statute requires. It talks about presumptive consecutive sentencing. And likewise, the disposition is a commit.
Can I ask you real quick? Sorry. The paragraph that says while under state authority, why is it labeled state authority?
I'm sorry, I didn't
I
hear
didn't hear the
that.
question.
It's the paragraph that's labeled commission of whatever a new offense while under state authority. You're not there yet because I'm still not seeing those words.
Which page are we on?
I don't know. You just went right by
I'm
it.
sorry.
So
Offenses committed under state authority.
So what page is that on?
so that's page
Page
11.
Yeah. It's at the top of page 11. Yeah, that's under 2C3. These are different provisions that always require a commitment to the Commissioner of Corrections.
So then the only concern I have there is, or assault against a county sheriff or sheriff's deputy in a local correctional facility, you're not under state authority necessarily. Or does this one require that you?
So you're suggesting that the title may be incorrect?
Yeah, I was more suggesting the title might be incorrect, but then I couldn't process enough to figure out what a better title would be if it's not that.
Question.
Commissioner Knutson.
Is the underlining of that title, is that new language or is that the?
That is a flaw with how the sentencing guidelines formatting is done.
Yeah, so that,
Where statutes have that in bold, the sentencing guidelines underline the prefatory
okay,
part of a statute. So that is not new language. That is existing language. The underlining that comes later is the proposed language.
so I was just trying to imagine what the situation is. So we writ somebody to come to court, we writ them in out of the state correctional institution, and they're in the custody of our local sheriff and they commit an assault. I don't know.
And that's what I was, sorry that I don't have this like figured out in my head, but I was trying to figure out, could this assault be against a county sheriff while somebody is in a county jail on a before commitment? Like they haven't yet been committed to the Commissioner of Corrections, yet they're in the county jail and they do the
Right.
assault. Or is it only people who have been committed to the Commissioner of Corrections?
Right.
Which would be a stupid distinction. So I feel like it's the broader group, right?
Yeah.
Yeah.
Statute clearly requires it, so.
The statute is the broad, the
It's like the
whole.
equivalent of
Yeah,
course.
yeah, I mean, the new law requires an executed sentence for these folks.
Right, but who are these folks? That's the question.
Yeah.
Are they people who've been committed to the Commissioner of Corrections, or are they anyone who commits these types of assaults? Yeah, that's what I think. That's what I thought. So then I think that title is the problem. That's all.
Chair Mitchell.
Commissioner Frace, did you have one?
Unless there's something in either the existing language of 2232 or the added language, it seems like it applies to anybody who's in a local facility for any reason. It could be pretrial, it could be misdemeanor, and assaults the sheriff or deputy sheriff. So it sounds, if that's plain language, then we'd have to change that heading to say something like committed while under state or local custody or something like that.
Yeah.
To your point, Madam Chair, this is the change that the legislature made to 609, to the title of 609-2232. They crossed off state prison and it just says inmates. So
Broad.
if we're okay using the word inmates, I think that applies even to an escapee. I think could be perhaps considered to be under the category of inmate.
What page is that on again? Oh, I found it. Could it be offenses committed while incarcerated or on escape status? Like, does incarcerated cover local correctional?
I would think so.
So while on incarcerated, so offenses committed while incarcerated or on escape status. How's that?
Just
I appreciate that because I think under state custody or state authority, probably find, especially we're living in. So. I mean, that's a bit.
Commissioner Middlebrook.
About offenses committed while under state or local authority.
I didn't know what authority meant. Okay.
I think the concern, I mean, it also includes the secure treatment facility, and I don't know
Oh.
that you can call, I mean,
Yeah, you're
I'd say
right.
they're incarcerated, but technically they're probably not incarcerated.
They're committed, aren't they?
Yes.
Yeah. That's a good point. So that blows that theory. Okay. So under state or local authority?
In custody or.
Under state or local custody?
I think the language that's under that heading is clear. So I just think we want to have a heading that's not clearly under inclusive. So I agree, state or local authority.
Yeah. I don't know how to make it better. That might be all we can do. Commissioner Moore?
I share Commissioner Middlebrook's concern that I don't know if somebody that's been committed to a secure treatment facility, I mean, I guess we would probably consider them in custody in a general sense, but technically they're not there because of any criminal, I think, I mean, they might be, but they don't necessarily need to be. And I guess wouldn't want to create a loophole or some type of ambiguity that could prevent crimes from being prosecuted.
So does state or local authority work for you?
I think it does. I think that's pretty general, from a standpoint of referring to who the authority is that has the person, in their, secure, or jail facility. I defer to my district court colleagues on that too a little bit, but I think that might work.
Commissioner Reeves, you had your hand up.
Offenses committed while under state or local correctional supervision seems to make sense to me. It's the probation officer in the room. I like state or local correctional supervision. That encompasses it for me.
It's the state hospital though, that's the problem. It like doesn't encompass that.
But there,
The secure treatment facility is the state hospital, like St. Peter.
but they're under a correctional sentence, right?
They could be their place for.
They might be,
They
no,
might
you
be
can
there under
talk.
civil commitment.
Yeah, they
And
might be
there's-
civilly committed.
Not
But still
necessarily.
supervision.
Madam Chair?
Commissioner Ladd?
Perhaps if we said offenses committed while confined under state or local authority, because they're in confinement and we're not deciding whether or not they're in, we use custody. It can be loosely interpreted,
Yes.
but if we say they're confined, because they would be subject to a hold order or something like that.
They would.
I like that.
Yeah.
Me too.
I like that.
That's good.
So it's while confined under state or local authority.
Good job.
So we need the confined in it. Or did you write? Oh, okay.
So but that covers escape, you think?
Oh, does that cover escape? Do we need to add or on escape?
It says from
It's
escape.
from an executed sentence.
Yeah,
I mean, they have to escape from where they're confined.
I think we're,
So many nuances.
I know, it's so ridiculous. Commissioner Ladd, or Larkin.
No,
Commissioner
I
Larkin.
think confined is fine. And I mean, when we interpret the guidelines, we use rules for interpreting statutes, and we also always say titles don't matter.
Right.
So it's good that we're trying to make this fit, but I think we only need to go so far. And I think confined probably does it.
Yeah, subheadings and titles are not defining
Right.
the terms, but this is more for practitioner knowledge, would be my thought.
I'm good with that. Yeah, I think that sounds right. Okay, so I think we've, are you good? You good with that?
Sure. All
Okay.
right, so, moving on then
Why are we
to,
working so much harder than it was?
Now I lost my place.
3, so we're on, page 13, I think. And this is codified minimum sentences for sex trafficking. You may recall you made a recommendation about this. And I'll tell you as a sort of guidelines maintenance, it would have been nice if they had just made it identical to crim sex 1 and 2. So let me start at the beginning. So severity level A and B on the sex offender grid are reserved for criminal sexual conduct in the first degree. That's severity level A. Some criminal sexual conduct in the second degree. That's severity level B. Sex trafficking in, aggravated first degree sex trafficking. That's severity level A. And then first degree sex trafficking, not aggravated, or aggravated second degree sex trafficking that's involving adults, that's severity level B. And the original bill that you wrote your recommendation on last month had a mandatory minimum, or really a statutory presumptive sentence. And I should probably talk a little bit about the difference between most mandatory minimums. Require a minimum sentence. Sometimes it's waivable, sometimes it's not. The criminal sexual conduct mandatory minimums are worded a bit differently. And the way the commission interprets that language is it says it's not really a mandatory minimum. It's really a directive to the commission to make that the presumptive sentence. So it's really a statutory presumptive sentence more than a mandatory minimum. And so they use the same language for this mandatory minimum. It's really a statutory presumptive sentence. But instead of using the existing mandatory minimum language of 144 months and 90 months for the severity level A and B offenses respectively, they just codified the existing footnote 2 on the sex offender grid. Maybe I should pull that up there. So here's what footnote 2 says. It's got to be this. So here are A and B with those statutory 144 and 90-month sentences. And because of those statutory presumptive sentences, the lower range doesn't apply here. So that's why you have these 144 and 90-month lower ranges, even though it really should be lower than that. But you got a footnote. So let's go down to footnote 2 and see what that says. So it says sex trafficking is not subject to the 144 90-month minimum statutory presumptive sentence. So the standard range is 15% lower than the fixed duration applies. So here it says for severity level A, criminal history 1 and 2, the ranges are 123 through 172, 133 through 178, and 143 through 201. So all of those go below 144. And for severity level B, criminal history score 0, the range is 77 to 108. So that goes below 90. So if they had just said 90 and 144, we simply could have deleted footnote 2, but they didn't do that. Instead, they chose to essentially codify footnote 2. So now we're stuck with footnote 2 forever. So so these ranges are literally mentioned in the statute, 77 to 108 and the 123 to 172. So now the commission essentially has to rank it the way it is currently ranked with footnote 2. So so what did the bill do? It didn't really do much other than require the commission to do what the commission already does. So back to the recommendation. So in 2G, which is modifiers, there's a provision about attempts and conspiracies under the modifier. And then 2G5 is basically explaining why this particular type of statutory presumptive sentence rather than a mandatory minimum isn't really subject to the normal rules of statutory mandatory minimums. It's because it's a statutory presumptive sentence rather than a mandatory minimum. Half time for attempts and conspiracies does apply, whereas it might not normally apply to a mandatory minimum. So we're simply modifying this language. Actually, we're cleaning it up a little bit. We're simplifying it to say that the presumptive duration found on the grid can be cut in half. The presumptive duration found on the grid with respect to these 4 offenses, which are all the severity level A and B offenses. But we're not doing any changes to the grid, no changes to rankings, no changes to durations with respect to the offenses. Consistent with what was clearly the legislative intent. So I bet that was pretty confusing. I apologize.
No idea.
It was a pretty confusing bill for something that didn't do anything.
Don't underestimate them.
But there it is. So any questions on that?
No, I actually want to commend you for making that somewhat understandable in your explanation. Thank you.
Okay, thank you, Madam Chair. So number 4 is really straightforward. Basically, it's a renaming child pornography as sexual abuse material. And I should say child pornography is not a term that exists in statute. That's a sentencing guidelines term, because the term pornographic work, which is the statutory term, really doesn't convey anything about the nature of what's going on. And so the legislature took it a step farther and called it child sexual abuse material, which certainly is an accurate description of the vast majority of what was previously called pornographic work. So basically we changed the term use of minors in sexual performance to add or child sexual abuse material, which was already in there. And then all references to child pornography become references to child sexual abuse material. And these, and I will say, because it's longer, we did take an example offense off the sex offender grid. So we're taking off the offense of solicit child for sexual conduct from severity level G. Any questions about these changes, Madam Chair?
Does anyone have any questions? Okay, so that gets to the end of section B, correct?
It does.
Okay, so we're to the end of section B. We have made a change to the title of that one offense. Does anyone want to make a motion regarding section B? Commissioner
Madam
Knudsen.
Chair, I would move the adoption of staff recommendations in the entirety of section B.
I'll second.
Do either of you want to add in the little edit to the title?
And editing the title as discussed, and language that was recommended by,
The language was welcome.
discussed by the commission.
Yeah, okay, as the language was discussed by the commission. Okay. Commissioner Middlebrook seconds. So Commissioner Knudsen makes that motion and Commissioner Middlebrook seconds. I'll give Nate a minute to type out the motion. Any discussion on the motion in the meantime? All right, whenever you are ready, we can vote on it.
To the Knudsen motion to adopt staff recommendations in Part B, except to retitle guideline section 2C3E as offenses committed while confined under state or local authority. Larkin?
Yes.
Larkin, yes. Phrase?
Yes.
Phrase, yes. Keefe? Keefe, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Mazaros? Mazaros absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller? Mueller absent. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
And with that, the motion is approved. Thank you. Last section is section C, legislative changes with no staff recommended guidelines modifications.
Yep, Madam Chair, these recommendations are, they do change laws, but there were no changes that we thought required any sentencing guidelines recommendations. I refer them for your reading pleasure, and I'd be happy to answer any questions that you wish about them.
Does anybody want further detail on any of the items in this section? All of the recommendations here are to maintain the guidelines as they are, despite there being minor changes to the statutes. So we actually don't have to take any action in order to do that. Okay, I'm going to assume that everybody was prepared for that one. So that I think takes us to the end of those active, the active changes under number 4 on the agenda.
That's right, Madam Chair. I do have some others legislative changes that I could point out in the executive director's report. at this
Okay,
time.
that sounds great. So then we will move on to number 5, possible sentencing guidelines technical modifications. This is also an action item on the agenda.
Madam Chair, so we've got two items here, and I could share my screen, but they're pretty minor. One is there was simply a changed statutory citation that we did not catch when it occurred, and which is inserting a paragraph letter A in 609.771. The second is, and that has to do with using deep fake technology to influence an election, which is a pretty new crime, but it's already been changed. And then the second is, we just noticed when we do have an appendix 3. Appendices are not really part of the guidelines, but we like to keep them current and accurate. We noticed as we were talking about appropriate rankings for criminal vehicular homicide, that criminal vehicular homicide actually already exceeds the statutory maximum, at least at the upper range, where it's currently ranked at severity level 8. So that upper range at criminal history score 6 bumps into the 10-year statutory maximum as it is. So we recommending including that in Appendix 3, which is a table that attempts to list such offenses that exceed the statutory maximum.
All right, questions on either of these? All right, so to make these changes, we do need a motion. So I would entertain a motion to make these changes, to adopt the staff recommendations here.
So moved.
Commissioner Moore makes that motion. Do we have a second?
Second.
Commissioner Larkin seconds. Any discussion on the motion? Hearing none, we will vote on that.
To the Moore motion to adopt the staff recommendations in the document numbered 5 in today's meeting materials. Larkin?
Yes.
Larkin, yes. Phrase?
Yes.
Phrase, yes. Keefe? Keefe, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Mazaros? Mazaros absent. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller? Mueller absent. Reeves?
Yes, excuse me.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
And with that, the motion is approved. All right, so we have made it through all the changes. Commissioner Middlebrook, you have a comment?
Sorry, Madam Chair, I
Yeah.
did have one question on that, on page 3 of that Is that supposed to be 10 under the statutory max in months in that chart?
Oh, thank you, Madam Chair. Well, we need to change that to 120.
120.
120 is 10 years, so that should say 120. So we will, without objection, construe that as the motion that was just made.
I don't think anyone objects to that.
Thank you.
Excellent. Okay, so just a reminder, Director Wright's already walked us through this, but what's going to happen next is all of the changes that we just voted on will now be moved forward to a public hearing. We'll have that public hearing in July. And anyone can come and give us feedback on that. If we receive feedback that might cause us to change a decision, we'll be coming back a week later to affirm our votes on whether or not these items should in fact be adopted and move into the next version of the guidelines. And if we receive any feedback that would change our mind on anything, then we would discuss it at that time. All right.
Can I just ask a general question about what
Commissioner
we just
Knudsen.
covered?
Yeah.
How many offenses or crimes do we have in Appendix 3 that the presumptive sentence actually does exceed the statutory maximum? And has there ever been a discussion with the legislature about that, or how can that be, or anything like that?
Good question. I don't know.
Madam Chair, Commissioner Knudsen, look. I mean, some of them are like this one where I would say it's a bit, it's a 10-year statutory maximum. The maximum penalty at criminal history is score of 6 is 108 months, but the upper range is 129 months. So it just kind of hits the ceiling there at the upper range at the very tippy top. So I think that's, to me, it doesn't seem untoward in any sense. But there are 20 offenses in there now, 21 after this is finalized currently. So it does, it's about a page and a half of offenses right now. And I will say that I don't think, at least staff has not at any time in the recent history, in the last decade, I can safely say, undergone a project to comprehensively look at every offense and make sure that, Appendix 3 is complete. It's kind of, as we observe discrepancies, as we did just now with criminal vehicular homicide, we put those in there.
Any further comments, Commissioner Knudsen?
No, just a curiosity.
Okay. Okay.
Yeah, and some of these offenses, it's interesting because the last column of that table is where it hits where it bumps up against, and really, I think the most interesting ones are where it's lower. Some of them are exceed the statutory maximum right away. So, yeah.
That's what doesn't make sense.
All right. Well, we're going to move on to item 6 now. That's the comprehensive review. It looks like the first item there is a presentation of offense group 3 for the ranking project that we're currently undertaking. So,
Madam Chair, I'm not going to take a lot of time because I did introduce this at the last meeting. And this is, I've never received a more positive response than any email I've ever sent out in my life. When I told you that you were off the hook as far as meeting what was admittedly a very, very tight.
I breathe a sigh of
Apologize for that.
relief.
But we did change it. We updated it to include domestic assault by strangulation, which is a felony for the first offense, even though substantial bodily harm is not required for that offense. I hope this is good news that we'd like to give you until June 23rd to respond to this. So that gives you 3 weekends, I don't know if you work on weekends or 2 full weeks, whichever way you want to look at it, to respond to this.
what was it again?
June 23rd, please. Yeah, by
Thank you.
the end of the day, or that afternoon or evening. We won't start to look at them until the morning of June 24th. So.
Commissioner Larkin.
When do we switch from Judge Knutson to Judge Castro? That's directed to Judge Knutson.
Tomorrow,
Are you serious?
No.
No, okay. So are you with us through June?
through June, yeah.
Okay, so you're gonna take on this? Thank you.
Yes. No, I think I'd have an obligation to finish up.
Okay, and I
do
don't
this.
mean that, but
No,
if
right.
not, we should try to loop Judge Castro. Has he been approved?
Not yet.
Oh, not yet.
Back to this, I didn't print out the new version. I kept my old version, and you're saying the only difference was the adding of domestic assault by strangulation, so that's the only couple pages I need to add to the old version.
I think that's right.
Okay.
We'll let you know if it's not.
Okay.
All right. Any other questions on that one? Okay, then we'll move on to item B, which is comprehensive review practitioner interviews. And Dr. Julia Laskarensky from University of Minnesota was going to give us a little more information to help with that ranking project that we're going to be undertaking by June 23rd. So we'll have her come online. Welcome. Please go ahead.
Okay, well, thanks for having me back. I appreciate the commission listening to another presentation from the Robina Institute. I'm going to go ahead and share my screen right now so we can get started on this. Okay, so do you see the slides?
Yes, we can see it. Thanks.
And I don't know if you can see me or not, but you don't necessarily need to, so that's okay. Okay, so today I'll be talking about departure patterns for practitioners, mainly defense attorneys and prosecutors across Minnesota. As you know, the Robina Institute has partnered with the Commission to support the comprehensive review. And in particular, one of the areas we're looking at are very high departure offenses. So a question we're trying to answer is, why are the guidelines not guiding in every case? And in the case of assault to and aggravated robbery, these are two very high downward departure offenses. And so while judges are the ones that can grant downward departures, prosecutors and defense attorneys also play a major role in shaping whether a departure occurs. So the purpose of the presentation today is to assist the commission members in their decision-making about potential re-ranking or legislative recommendations. And it's also to provide insight from prosecutors and defense attorneys on why departures happen for high departure offenses. So your staff has already put together current departure trends for these offenses, which have been very helpful. We can start with assault 2. This is an offense where subdivision 1 requires assault with a dangerous weapon, and subdivision 2 requires assault with a dangerous weapon and inflicting bodily harm. They're both ranked at a severity level 6, and the mandatory minimum plays a major role here in that it applies to all instances of assault 2. With a non-firearm offense, you have a 1 year and a 1 day mandatory minimum. And with a firearm offense, you have a 3 year mandatory minimum for the first time. The departure rates for this offense are particularly high, even amongst high departure offenses. In over half of the cases, their individuals are given probation despite the mandatory minimum for a prison sentence. And that's a little bit lower for subdivision 2, a little bit higher for subdivision 1. There's also some durational departures, but not as high as some of the other offenses that I've looked at. What I'm gonna present on today are essentially themes from interviews that I conducted over the last several months with prosecutors, defense attorneys, and DISPO advisors across Minnesota. These were semi-structured interviews, lasting essentially between an hour and 2 hours, where I asked them about their departure practices, when they've seen departures occur, and asked them more specifically about any policy recommendations they may have across 5 specific offenses, and those offenses are assault 2 and aggravated robbery, which I'll talk about today. And then I will also come back and talk to you about the departure patterns across criminal CDH, felony DWI, and failure to register. So I focused the thematic analysis on the perceptions and reasoning behind departures and recommendations for policy changes, like I said. And the themes I'm going to report on today appeared multiple times across both defense attorneys and prosecutors. So the most common factor supporting departures, again, we're going to start with assault 2 cases. The one that was mentioned in almost every single interview was that this is an offense that has a wide statutory sweep, and that encompasses a lot of different types of behaviors. So a prosecutor from a rural area says, we have a lot of assault 2s that some of them are really, really bad, multiple shots, maybe a person injured. And then you have on the other side, a person waving a gun at somebody in a road rage incident. There's such a wide swath of what those crimes could be. And kind of within that wide statutory sweep reasoning, you have the second most common departure reason listed is that this is an offense that may have a low injury, right? And so a defense attorney from a rural area says, you could have assault fear type cases, the assault wasn't completed and they don't have to prove the bodily harm. That's probably the biggest part of it, because there wasn't an actual injury and maybe not prison worthy on a lot of it. Another factor that was mentioned is that because this is an offense that where you can that requires a weapon, there was a consensus that a lot of times when it's a non-traditional weapon, and a traditional weapon is generally considered a knife or a gun, but when it's a non-traditional weapon, that there is an increased likelihood of departure. So in this case, a defense attorney from an urban area is talking about a case that she had. So she said, the dangerous weapon is a butter knife. 2 sisters are fighting. She's jamming this butter knife through the opening in the door, saying, give me my stuff. I don't think that's on par with a stranger pointing a gun at your head. So here she's talking about kind of a non-traditional weapon that maybe is in a situational context where there's less danger than somebody, pointing a gun at your head. And she's also underscoring a context where this is a relational offense. Maybe this is a fight that got out of hand. This isn't somebody going out and victimizing the community. Defendant characteristics were commonly mentioned as reasons for departure. The most common one, overwhelmingly, was young age of the offender. So a defense attorney from an urban area said, sometimes you get a lot of people who are in their late teens, early 20s, who just did something dumb. And then low criminal history score, or particularly first-time offenders, were mentioned as strong justifications for a departure from a prison sentence. So a prosecutor from an urban area mentioned, I think the biggest thing is a first-time offense, no criminal record history at all. Most prosecutors aren't sending you to prison for that. A third defendant characteristic that was mentioned was, of course, amendability to treatment and community supervision. So a dispositional advisor from a rural area said that the way that they ask or that they secure departures is that they essentially make the case to the prosecutor and the judge that this person is doing well already, right? Because there's a period of time between when they can get out of jail and the court hearing actually occurs for sentencing, right? So on the ones that end up getting probation, they've gotten out of jail, they've done a treatment plan, You're getting biweekly updates. You put forth that sentencing argument. Look, judge, X, Y, and Z has already been done. And I actually have a fair number of those prosecutors who, if the client has done a lot of the stuff, they're not opposed to putting them on probation. I also, one of the themes that came out in the interviews, particularly with this offense, is that there are major victim preferences and roles. So a defense attorney from a rural area notes that if it's a second degree assault where no one was hurt and the victim in the matter doesn't want that person to go to prison, it's a lot higher chance that there's going to be a departure. So there are also systemic and practical considerations with this offense, and this is actually true for both aggravated robbery as well as assault too. But these don't necessarily reflect the guidelines per se. They just reflect the kind of case processing issues. So a prosecutor from an urban area notes why they would agree to a departure. So they often note that, departure requests from defense happen somewhat last minute. And he's saying, and then you're scrambling to try to make sure that, do you have a case? Is your victim here? A lot of times on these assaultive cases, the defense just waits till trial to see if the victim's going to come or not going to come. And so if they don't have a victim, often they will try to settle the case through a departure. Also, another factor, and while this doesn't directly have to do with the departure statistics that I presented at the beginning of the presentation, a fair number of these cases do get settled to threats of violence rather than going for a departure. So this was mentioned in multiple interviews across both defense attorneys and prosecutors. So a prosecutor from a rural area said, we do settle a fair number of assault 2 cases down to threats of violence. If we're going to resolve it to where we think that non-prison is appropriate, we're going to resolve it with a guideline to stay charged with threats of violence. That is something we, as far as I know, we don't have a lot of statistics about. It would be nice to figure out if there's a way to kind of get at some of those numbers. Overwhelmingly, there were challenges with mandatory minimums. That came out in almost all the interviews. So a majority of defense attorneys and prosecutors expressed negative sentiment to the mandatory minimums that apply to assault 2 cases. The reasons for, so for example, a defense attorney said that this is a major reason for the high departure rate, right? With assault in the second degree, it's certainly that judges and prosecutors are trying to get around that mandatory minimum. A prosecutor in an urban area described how these mandatory minimums are not designed with the full range of cases in mind. So mandatory minimums are so hard because every case is so different. It does sort of hamstring you at times when you have a case that, boy, in this specific situation, that's not what I think anybody was talking about. And in general, the mandatory minimums are seen as too harsh with the level of too harsh or disproportionate to the level of danger or harm with these cases in general. So another prosecutor from an urban area said, I would say when you're coming with your first time offense or second time offense, a lot of those departures are happening because of the amount of time that those individuals are looking at. So if I have a guy coming in on assault 2 and he has no criminal history record, and the presumptive with no criminal record history is 48 months, and maybe he just flashed a gun at somebody, right? Or she assaulted a relative with a knife and they have no criminal record history, like likely nobody's going to send them to prison for 48 months. And so I know one of the considerations in the packet that the staff have compiled for you on these offenses, look at how often departures happen at that GTZ line at the, when a person has no prior criminal history. There's a marked increase in the likelihood of a departure. And I think these interviews definitely support that. So policy considerations from this set of interviews on assault 2. So I did for every single individual that I interviewed, I asked them whether this offense is ranked correctly, whether it should be re-ranked. For this offense in particular, it was hard to get people to talk about where it's actually ranked at a severity level 6 because they had so many issues with the mandatory minimum. So, but if you set the mandatory minimum aside, most people did say that it's largely appropriate, ranked at a severity level 6. But again, that mandatory minimum is making things confusing. There was also just in the interviews, strong support for explicitly differentiating between assault 2 types, particularly between fear-only offenses versus actual bodily harm. However, that didn't always translate into a recommendation for re-ranking. Again, I think because the mandatory minimum kind of makes that separation null because it doesn't differentiate. So there was also commonly mentioned that this is just a very confusing offense because it is ranked at a severity level 6, but the mandatory minimum does apply to it. So several people said a sentiment that a defense attorney from a suburban area has here. I just think it's really confusing because it clashes with the statutory mandatory minimum. It's like secondary assault is its own category. It doesn't even fit on the grid because of the mandatory minimum. So perhaps the commission can consider that. I'm gonna briefly pause here before I go to aggravated robbery. Are there any kind of clarifying questions I can answer for anybody? That was a lot.
Questions?
Yeah.
Director Wrights has a question.
Sure.
I'm wondering, did you get into the difference with, I know you talked statistically, but did you get into the difference between subdivision 1 and subdivision 2? And the fact that they're ranked the same, but subdivision 2 requires the infliction of substantial bodily harm?
Yes. I mean, I believe, I mean, so I don't know that individuals specifically focused on subdivision 1 and subdivision 2, but there were a few interviews that kind of broke it out. But again, the actual bodily harm cases were viewed as much more severe. This was apparent, not just for this offense, but for aggravated robbery as well.
Other questions from Christian members? All right, I think you can go on to aggravated robbery.
Okay. So similar, this is there are some similarities between assault 2 and aggravated robbery, but there are also some major differences. So for an aggravated robbery offense, this is the taking of personal property from someone by force or threat of violence. And it also requires either a dangerous weapon and/or infliction of bodily harm. This is an offense where that is above the disposition line, so it's severity level 8. So right off the bat, you have a presumptive 4-year commit. There is a mandatory minimum that applies to some instances of this offense, although the presumptive 4-year commit is generally above most of the mandatory minimums in this case. And so the mandatory minimums did not play a major role in kind of the conversation around this offense. This offense, again, as your staff has already put together, that this is a high dispositional departure offense. It's also a higher than average durational departure offense. So more than a third of individuals who do get prison get a sentence length that is below the guideline recommendation. So again, the most common factor mentioned that in prosecutors and defense attorneys thought led to departures was that this is an offense that has a wide range of behavior. And so, for example, a defense attorney from a rural area is saying it's different when it's like, hey, I just pulled up next to some guy on the side of the street and said, give me your wallet, give me your phone, versus you have a fight between friends and I had punched him and I took his wallet because he owed me money, right? So we're talking here about an impulsive act, a fight that got out of hand between two people that know each other, where one person may not want the other to go to prison, rather than deliberate planned violence where somebody's going out and, looking for a victim. The other reason most commonly given was that these are offenses that may have minor physical harm. So you can have a robbery that causes a bruise on a person's hand. That's going to be an aggravated robbery. The idea that we're going to treat that as the same as someone who points a gun and puts a gun at your head, to me, is preposterous. This is a defense attorney from an urban area. Defendant characteristics also played a role in this offense, and I would say even more so than assault 2 cases. The age and the immaturity of the offender was mentioned quite often. And in particular, this was often mentioned in unison with kind of involvement in drug-related offending. So individuals who may be younger individuals who may be involved in the drug trade and were already involved in illicit activities that, got even more out of hand. So a prosecutor from a rural area is talking about a case that he currently has. So this is a robbery gone bad and a park drug deal. I'm asking for prison and he's asking for a departure, and he's a young kid. He's 20 years old. He's got a troubled chip history. And he might get a departure, right? Defense attorney from a suburban area also says that this is an offense that's often for young men, and they get in these groups and they're like 18, 19, 20, and this happens. And if they can just get out of this young man phase, they will not be doing this again. So those are where I see a lot of the departure rates.
Well, that's the major problem. The young man phase usually lasts until the man is old. Just lasts way too long.
Yeah, I did not get a cutoff on that, but I assume, yeah. I think what the staff put together kind of mirrors what this says as well, right? This is overwhelmingly a young person's offense, and I can't remember this exact statistic, but it's like almost everybody is in their 20s, right? Limited or no criminal history was actually cited less frequently for this offense than with assault 2. In fact, I had several participants say that at the point when they're getting charged with aggravated robbery, they're generally getting, it's not their only charge. And also that this is, it's often not their first charge. So this was not, so that's one major difference with assault 2. So then you also, for this offense, you have practical and systemic factors that were mentioned quite frequently, particularly around the credibility or cooperation issues with victims, especially during illicit activity. So multiple mentions that this is, again, an offense that can occur during illicit activity, such as dealing drugs, prostitution related acts, or in general, or gambling, right? So these are illicit activities where a victim may not want to cooperate with the prosecution anyway, and they're cases that are just generally hard to try. So prosecutor from a rural district, we're more likely to say, okay, we would agree to a departure in this situation because our case isn't as strong as we thought it was. Our victims, a lot of times they have crimes that they can be impeached with. And so when we're putting them, when we're putting their credibility on the line, the jury is probably going to hear that they've been convicted of a felony or two or more. And so then we're going to have to say you lied to the police, et cetera, et cetera. Several prosecutors also cited just heavy caseload pressure. And this was true not just for this offense, but I think the heavy caseload pressure coupled with having this case be more difficult to try led to higher departure rates for this offense. So a prosecutor in an urban area saying, you see it time and time again when you're so inundated with trials that you're giving away the farm. You got 8 trials set for today. 3 of them, you don't have any victims. 2 of them, you don't have any witnesses. And then you're like, okay, well, what can I do to get a plea out of this? You know he did it. It's not like you don't have the evidence to do it, but can you prove it? So there were also some judicial and prosecutorial discretion themes that I wanted to present on. One major thing about this offense is there were some differences across prosecutors and defense attorneys. In the general, there was a general prosecutorial reluctance to offer departures, especially when a dangerous weapon was present. This was just an offense that was taken quite seriously by prosecutors. And so what that means is there was a general sense that judges were more amendable to departures than prosecutors were to plea bargaining this offense. So a prosecutor from a rural area is saying, we've had one departure in our jurisdiction where the amount of money stolen from the victim was $10 and the judge gave less time, but still executed the sentence, which I thought was ridiculous because the act shouldn't be based on how much money was stolen, because it's violence towards another individual using a weapon to steal. So again, these were generally considered quite serious offenses where there was a risk to the community. Another factor at play here is that both, and I would say this was mentioned in almost every single interview, both prosecutors and defense attorneys note frequently that there were frequent charge amendments from aggravated robbery to lesser charges of simple robbery, similar to assault 2 with the terroristic threats. But this was true particularly in less serious cases where there wasn't a lot of harm, or in cases that are just simply hard to prove and just need to be settled. And so you have a prosecutor in an urban area saying, sometimes if a weapon isn't found, that can make things harder, especially if you have any credibility issues with your victim and you don't have a weapon. That's a pretty good time to say, even if we go to trial, they might believe everything, but we're not going to be able to show a knife or a gun because they got away and either hid it or whatever. So in those situations, it's much more likely to go down to a simple robbery or just, negotiation tactics. And so a defense attorney in a rural area similarly says, usually what I've had is if it's a non-firearm or a non-weapon, even ag robbery, they just give you a simple robbery, right? And by they just mean the prosecution. So a little bit more specific policy recommendations on this one when I asked participants about it. So is this offense ranked appropriately at a severity level 8? The most common answer by far was that it was appropriately ranked at a severity level 8. Despite the high durational departure rate. The second most common answer, so slightly fewer people answered this, was that the offense was ranked too high when minor harm has occurred or there was no weapon used. And it was really interesting. I tried to figure out if more people thought that when minor harm occurred, it was a less serious offense, or when no weapon was used, it was a less serious offense. And it really was pretty evenly split. Some prosecutors and defense attorneys, just really focused in on the fact that when there's very little harm or no harm, that this is just a lower ranked offense. And others really focused in on the fact that sometimes there's just no weapon and it's just not, they didn't consider it to be as serious. Use of a gun was taken quite seriously across the board, even if no harm occurred though. So, for this offense, more than assault two, so more participants noted that departures occur, particularly just, durational departures, because the ranking can feel overly harsh for borderline or less violent cases. Again, this is an offense where the mandatory minimum is just not coming into play as much. And so you're starting off at that 4-year commit. So that would make sense in terms of taken together with the high departure statistics. Overall, these interviews show that departure decisions in structured sentencing systems such as Minnesota's are shaped by a mix of legal, contextual, and individual factors, reflecting the ongoing tension between uniformity and discretion in sentencing. I would be happy to come back and analyze, and I need probably another month to analyze the interview data on CVH, felony DWI, and failure to register. In the meantime, I am happy to run any queries that clarify the presentation, the interview findings, and any implications that you may have for re-ranking. Thank you.
Thank you very much. That was really interesting, quite informative, and I appreciate the work that you've done so far. I'm looking forward to the rest of it, hearing the rest of it. Questions, comments from the commission? Commissioner Frace.
Thank you, Madam Chair. Well, I had a narrower thought, and then it grew into a broader thought. The narrower one was in talking about the youth factor, and that some crimes, especially crimes like robbery, are often committed in a group. We know kids do things in groups that they wouldn't do alone. That was true of me. It's true of most people who do delinquency. But and I guess the broader question is, there is a departure factor for minor or passive role. There are a bunch of other listed departure factors. I guess I'm just wondering, it would be nice to have it for ranking exercises, but just to corroborate what your interviews are showing. If we could have, I haven't seen it, maybe we've been given and I missed it, some kind of statistical report of what reasons for departures judges give for these crimes.
First of all, I just want to see if Nate recalls if we have done that in the past, and if not, maybe that's something we can get.
Yes, it's data we have. If the judge reports it, we report that data.
I guess a complication is that I looked at this from time to time over the years. There are, as you know, lawyers and judges will do, the tendency to cite more than one reason. And it's complicated to, there's no way of knowing which were the most important reasons. And if you just say, here's the frequency report for reasons for these, let's say mitigated dispositional departures, if you just tote them up, you're going to have more reasons than there are cases. But it's still useful information.
Yep. Okay. So we can work on getting that. Commissioner Larkin, you had your hand up.
I did not a question, just a comment. Okay. Big picture, the way the guidelines are structured and the case law talking about departures is very stern. This is a sentence unless there are substantial and compelling circumstances. In the Soto, I think in Soto case, Justice Lilliehog said, well, just because you're amenable to probation, that doesn't mean you should get a departure. It has to be, I forget the adjective he used, but particularly amenable to probation. And Justice Blatz wrote, these should be far and few between. We shouldn't be having these departures. It seems to me that one of the problems we have is things are ranked and mandatory minimums are imposed, I think, based on the worst case scenario when you think about any one of these crimes. But then we're hearing all of these sort of circumstances that influence the sentencing decision. Oftentimes they result in the charge going down, which avoids the whole departure issue, which would probably be what we would do in a perfect world. But I wonder if there isn't a world where we identify, and I think this might just kind of piggyback on what Professor Frey said of, what are the circumstances that are causing departures over and over and over again, and somehow acknowledge those in the guidelines. Because then you would sort of counterbalance this. You need particularly amenable to probation, you need this or that. I mean, if everybody is saying, well, this universe of circumstances tends to indicate that the crime is not as bad as where we have it ranked, but the prosecutor doesn't want to reduce the charge, understandably, because if the person screws up on probation, you want the full boat, you don't want the reduced amount of time. I mean, is that something we can look at? Something that says, okay, these are generally accepted reasons for departures, and kind of chip away at this notion that, every egg robbery is the same, every second degree assault is the same, they should all be going to prison, when in fact, that's not what's happening, and both sides agree.
Yeah, I think that that's a point well taken, and it is part of why we asked for this type of feedback, partly to see, is it a legislative issue? Is it a guidelines issue? And, like, I'm hearing some factors that, might help us differentiate cases. So like we could differently, I'm just making stuff up, but we could differently rank an offense that involves a gun from an offense that doesn't involve a gun or something like that, if it's one of the elements of the offense. So, I mean, we can think about, are there ways to do those things as we rank offenses?
But the ranking won't get around mandatory minimum.
Well, yeah, we'd also have to make recommendations on that line if we thought that we should. Commissioner Ladd and then Commissioner Keefe.
So I just think, one of the things just in talking about the second degree assault and the egg robbery, and I'll use quotes from the presentation, when we talk about a wide swath in terms of like everything that falls in the bucket or a wide range of behavior. And I think therein lies our problem, is that there are so many scenarios and circumstances that go into this. And as a prosecutor, I wish I had a crystal ball to know sort of like, if I'm going to give somebody a departure and agree to it, that's a good thing. And it's not a bad thing for the victim and public safety. I don't get a crystal ball to make those decisions. I think the other thing that I'm picking up on, and I feel like, I don't know if it's in the purview of this body or not, but the fact, I'll just talk about second degree assault. The fact that we have second degree assault that has a dangerous weapon that is either a firearm or a non-firearm, bats, pipes, those kinds of things are common things that we use that trigger those mandatory minimums. And maybe you don't like the fact that there's not bodily harm involved, but guess what? The legislature doesn't require that there's bodily harm associated with the use of that weapon. So the fact that we're kind of wrestling over the fact that there's these threats being made, and again, is it a known person? Is it a family member that person doesn't want to cooperate in your case? Or is it some stranger person where there's this event that occurs and there's a weapon involved? So again, those things matter, because I will tell you from a prosecutor's perspective, how victims want to cooperate or not is huge. Not only in the case, but if they want to cooperate, and then they sometimes they want more than what we are even able to do. So I think, again, that's the kind of weapons that are being used, and the fact that there's an injury or not an injury, that's baked into the statute. That's not something for us to sort of like or not like. But if it's an issue to sort of separate how we rank those, that might be consideration. But we don't get to not like the fact that if I have a gun and I threaten you and you're not injured, that somehow shouldn't have a consequence that we attach to it. That's what the law is, right?
Yeah.
And again, I think the same kinds of things with the aggravated robbery, when you talk about the wide range of behaviors that come into play, two people are fighting, somebody ends up getting their wallet taken, versus, a stranger rolls up on you, assaults you, has a weapon, and takes your purse, takes some property from you. I mean, those are varying things that happen, and I just think that those play into our role, because if you don't have your victims, they're not cooperating, or again, you don't have the weapon, all those things play into the disposition ultimately. And I think a better practice, and this is just my 2 cents on it, is that if we could have them plead to a different charge as opposed to a departure, that'd be great. But you know what? Sometimes we can't come up with a charge that fits the facts and circumstances of the case. So you can't manufacture sort of a lesser included or some alternate plea to something else because the facts don't support that to be able to make a factual basis. So I think that's kind of the rub with trying to plead to a different offense versus having to have them plead to what they actually did, but give consideration maybe differently under the guidelines. So I think those are the tensions that I don't know how you, because it's so broad, how you fix it. And I think that's why we have this list of reasons for departure that have to be articulated and a finding needs to be made. And I am curious, and I've asked this question before, and I don't remember what Director Wright has said. So commonly, prosecutors will stay silent at sentencing. They won't agree to the departure because there's not a reason. I'll say, I can't come up with a reason. If you can sell the judge on and come up with a reason, but I said, I'm going to say I'm recommending a guideline sentence. I'm not agreeing to it. I say, I don't argue against it. So I'm not agreeing to it. The court hears the defense spiel and makes a finding that there's a basis for departure. How does that get recorded on the sentencing paperwork in terms of, did the prosecutor agree or did the prosecutor, how does that get memorialized?
I don't think we have a code for silent at sentencing.
No.
I will tell you that happens a lot.
I used to do that a lot.
It happens.
And so it's really up to the judge and the judge wishes to memorialize that.
Because I mean, I think that might skew, I feel like that it makes me feel a little bit like when it says, like the prosecutor didn't object or the prosecutor agreed. Does that what that means? Is that by the default? Is that the default?
I think it's agrees / does not
It's your
object.
fault.
So it would probably go into that bucket.
Mhm.
And I agree that's a pretty big bucket.
And maybe that's part of our problem too, is that we're sort of over categorizing some of that because that's a pretty common practice to say, I don't agree with the departure, but I'm going to let them make the pitch to the court. And if they can sell it to the court, it is, but we're not agreeing to it. That's what we say. We don't say anything else. And so there's not a plea agreement. It's basically an open plea to the court. So I just didn't know how that was memorialized for data or for recording that kind of data.
Yep. All right. The answer is it's vague. It depends. As
Okay.
usual, Commissioner Keefe.
I'm curious whether we can get data, to your point about victims' perspectives about the sentencing guide, either victims or advocates. Just because so many of the comments that talked about the departures were tied to whether the victims are participating in prosecution, or seemed like the victim's credibility is part of the case. And victims have such, like, the spectrum of perspective is really varied depending on the relationship, things like that. And often it's either because they're worried about retaliation, or because of their perspective about the person and what they actually want for the case. So it would be great to be able to victim voices be part of the.
A good point.
Did,
Oh,
oh, I'm
go
sorry.
ahead.
I'm sorry,
ahead.
Chair Mitchell. I was gonna ask, did MAD do any sort of focus groups with victims?
Do you remember? Yes, the answer is yes. So we could go and look and see, are they still on? They're still with us for a couple more days, right?
Yes. I think they're writing up a.
They're writing up a report, but maybe we could ask them that question specifically if they could look at the victim, the feedback that they received from victims, especially on these offenses that we're going to be grappling with at the end. Might be helpful. Did you have your hand up,
I
Commissioner?
did.
Commissioner
I'm
Larkin?
just saying that one thing I've grappled with my entire time on the commission, which has been years now, is we wanted the sentencing guidelines for a certain purpose, and that's uniformity. And all the complaints that we hear are that it's sentencing is not uniform. There is a wide range of conduct. There's a wide range of defendants. There's a wide range of circumstances that call you to negotiate cases. I don't know if it works. But I understand, the goal is consistency. It's just, how do you get consistency if you're going to have all these exceptions? I sometimes wonder if it's a system that can be maintained. I just say that because we so often hear things that indicate you want judges to have more discretion to do what's right in a particular case based on the particular circumstances, especially when the prosecution and defense are agreeing, or to have the ability to do, hold your nose and do what you have to do in a case that's going to fall apart. And I mean, under those circumstances, and that's a whole lot of the cases, I just don't know how well the guidelines work. I mean, do prosecutors reduce a charge to get below the commitment line and then impose an upward durational departure on the theory that it's worse than the crime at that level? And I mean, we have, I think it's Ms. Gwandis saying, the Supreme Court says sentencing according to the guidelines isn't a right that you can waive. So defendants used to agree to departures in order to settle their case to get a chance on probation. We can't do that anymore. It just seems that we've cut off a lot of the ways that would make sentencing more palatable to everybody. Not a very positive comment, but
Well,
over the years.
I'll push back a little bit and I'll say that one of the things that we heard, for instance, on assault too, is that it's an offense that covers a range of behavior. So another option is for the legislature to hone it in so that you do have that other offense that you can charge instead of assault too. And so it's not always about, can the guidelines get to the right place? It's do we have the offenses defined in a way that help us get to that place where we can consistently recommend a particular sentence for an offense. So there's more than one way to think about this too. Commissioner Keefe.
I think something that you had suggested too was thinking about what actually drives the departures and whether that's the problem to solve for. I do think that that's an interesting question to consider. I know there was a study around domestic violence and victim engagement in prosecution. And this study was Cook County. They provided a large amount of support to victims with high-risk cases. And what they found was there was a dramatic increase in victim participation in prosecution. And so that was what was needed in order for there to be more consistency in cases. So just thinking about what that actually looks like and trying to solve for that. I have another thought and it's gone. So let's stop with that.
That's very interesting. Thanks for raising that. I would love to see the study. If maybe you could share that with the commission. I don't think I have seen that one. All right. In the interest of time, I think we'll bring this one to an end. Thank you again, Dr. Laskarensky, for your work. Really intriguing and thought-provoking presentation today. I appreciate it. So now we'll provoke our thoughts in a different direction, and I'll ask Professor Kevin Wrights from the University of Minnesota to also share his thoughts with us.
Thank you, Chair Mitchell. Let me see if I can share the appropriate screen. Okay, looks like that's working. It's good to be back before the commission again. Today I'm bringing forward the latest installment of a conversation that we've been having since the very beginning of the comprehensive review. It makes sense that one thing to look at in a comprehensive review of the guidelines is what the guidelines themselves say about their underlying purposes. And the language is clear in current statute and guidelines that public safety is a leading purpose of the guidelines, but so is proportionality. And we have some history now discussing at commission meetings what more the guidelines might say about public safety. So I'll restrict my comments today On that, I think there may be useful things that the commission could add to the guidelines on the subject of proportionality, but that would be for a different day. The concept of public safety and proportionality for that reason, also it appear right at the beginning of the guidelines in guideline 1A, which is goes on from here, but the first subject introduces the subjects. And what we've discussed before and what I bring to you today is actual proposed drafting language that might be added right below the paragraph that introduces the ideas of public safety and proportionality. And the language in the handout and on the slides is exactly the same, but the part of the language or part of the drive of this this new wording is to expand people's understanding of what public safety is. It can mean different things to different people. It's the primary purpose, the legislature says, under the guidelines, and yet we allow it to mean to be in the eye of the beholder. So in the first several lines of this provision, this is similar to what we've talked about before, and I think in general, this is language that the commission has greeted favorably in the abstract. So this is an exercise in actual wording. But the beginning of the language says that public safety it means a number of things. It includes a number of means to prevent future crimes and victimization, including rehabilitation, general deterrence, incapacitation, and reintegration of ex-offenders into the law-abiding community. Okay, now I stopped there because beyond that, the draft includes language that I haven't before brought before the commission. In the last meeting that we discussed this, I think it was in February, I had some slides that suggested language that sentences should avoid penalties that tend to actually increase the possibility that the offender will commit a crime in the future. And there was a very good discussion around that. And this draft states a different idea, I think, and yet raises a similar sort of concern. The last 2.5 lines say that reasonable caution should be used at sentencing in the use of penalties that could hinder offenders' progress towards rehabilitation or reintegration. In my view, and it's the commission's view that matters, not mine, but in my view, many people who take sentencing policy seriously think about it in this way. What can we do to reduce future criminal behavior and keep in mind that there's some danger that certain sentences could actually run contrary to some of the primary concerns we're working towards. The wording here is softened from the wording in the model penal code, for example, but just stresses the use of caution about what you might call unintended side effects or unwanted tendencies of sentences in some occasions to make things worse, not better. This is something in my career that clearly happens some of the time. And directing judges' attention through the guidelines and the general public's attention through the guidelines, to me, would be a positive, but again, it's members of the commission whose views matter. what I advanced today is simply not, I don't think, Chair Mitchell, this would be for a vote, but just something that tries to get closer to the actual language that the commission might consider. And again, just stressing that within a comprehensive review, it does seem natural that one focus would be the commission statement of general purposes of the guidelines.
All right. Do you want comments now, or you want to open it up for comments or questions, or?
I think so. I think
Yeah.
the question is, does this capture sentiments that the commission would like to add to the current statement of purposes and the guidelines?
So while people are thinking, I will just say that there's no voting today. Today is just about feedback and discussion. We will be bringing all of the ideas we've been discussing over the past several months to the full commission meeting in August. So you potentially could see some version of this language there as well. But we would want to, I'm interested in people's feedback today about adding this, something like this, to purposes and principles section. Commissioner Larkin?
How did you know?
Because
Mine
you
is just
took the
words.
deep breath like you were
Words.
ready to talk.
To me, it's odd to say public safety includes a number of means. I would say public safety includes prevention of future crimes, rehabilitation. I would just word it differently. Because we're seeing what public safety is, not what it includes, I think, the goal.
One reason I use the word include is to leave the possibility open that there may be ways that people can think about, increasing public safety that aren't captured in the specific things. To say that it includes doesn't exclude a new good idea.
Oh, and so actually, let me see this. So the structure is, you're trying to say that public safety is prevention of future crime and victimization, and that these items listed here are some of the ways that happens, but you're trying to make it a broader list, like a list that's not exclusive. It doesn't exclude other things.
Right. And I think about public safety to some degree as changes in environmental conditions. Public safety can be advanced by putting lights around a park at night. But in this context, public safety addresses what happened at sentencing.
Mm-hmm. Commissioner Freeze?
Thank you, Madam Chair. I guess I guess piggybacking on the idea that there could be other broader means, including means that relate to the sentence itself, not to sort of changing environmental factors, reinforcing important values. It's sometimes called, denunciation and norm reinforcement, educational effects of criminal penalties. I mean, those in a sense are part of proportionality. And so, but I guess I don't see proportionality and public safety as necessarily non-overlapping and totally separate. So I guess the value, I guess I'm speaking in favor without, complicating this unduly and having some lists of public of punishment purposes are so long they're not very useful. It's just so I'm not really looking to make this a longer list, but I guess we'll have to struggle with the wordsmithing. But I take the point about includes, avoids the problem of leaving things out I mean, I would argue that reinforcing norms of behavior and habits of mind, this is more serious than that, is one of the most important purposes of punishment, and it has a public safety component. People like us obey the law because instinctively we know that's wrong. And this is wronger than that. So anyway, there are many meanings of public safety.
Mhm. Yeah, maybe instead of making the wording of this sentence longer, that could be stated in the, if we were to revisit the wording of what proportionality means, that could be stated, or that overlap could be referenced in some way.
As you know, I'm on record as arguing that there are public safety, utilitarian, not retributive reasons for proportionality.
You have to unpack that for everybody else.
Well, punishing, this goes back to Jeremy Bentham, he's not a retributivist. He's just about public safety. But he said, among other things, that sentences should be proportional to the seriousness of the harms, to give, among other reasons, to give offenders a reason to prefer the less serious crime. Sometimes they have am I gonna use a gun? Am I use a loaded gun? Can I get what I want and sign up for less punishment? No, I mean, it's anyway, there are public safety reasons for proportional sentencing.
Mhm. And we could certainly add to the language if that's.
Other comments? Commissioner Leck.
I didn't raise my hand.
Oh, it's because you both have an L. I am sleep deprived because my son graduated last night. And
Congratulations.
Thank you. I'm not doing very well, but Commissioner Larkin, I'm sorry.
I understand what you're trying to do here, but to me, there's a certain disconnect. Because if you say we're defining public safety, we should just say what public safety is. And instead of doing that, you're saying, here's how we accomplish public safety, as opposed to what is public safety. That's my concern with the language.
So, Madam
Yeah,
Chair,
you might say public safety is promoted by a number of means.
Well, it's more like public safety, for our purposes, within the guidelines. It seems like public safety is means prevention of future crimes and victimizations. Public safety can be accomplished by, like it'd be a second sentence, right?
Yes.
I get that. Commissioner Knudsen.
we're taking all of the concepts of what we believe is to be accomplished in a sentence through sentencing, and kind of combining them now and saying, well, public safety is accomplished by rehabilitation, incapacitation, all of the other aspects of why we sentence people. I typically say, my sentence here is to accomplish a number of things. It's to punish the individual, to provide rehabilitation, to ensure deterrence, and to protect the public. But now we're saying, well, and public safety is defined as all of these, can be all of these things. So, we're just using all of the different aspects of a sentence to redefine one of the individual aspects of why we sentence. I don't know if I'm making myself clear, but you can also say, well, let's define rehabilitation. Rehabilitation is achieved by punishing the offender. Can be defined as punishing the defender, or the offender. I don't, we're not, we're almost circular in how we're defining and trying to fit in as public safety as its definition includes really rehabilitation, and all the rest of the reasons that we sentence somebody.
Mhm. I think part of the reason for defining is that not everyone who hears the word public safety necessarily takes the broad, I mean, I agree with your view of public safety, but it's a term that people read in different ways. Sometimes the word public safety are a kind of symbolic stand-in for tougher, longer sentences, as opposed to other things that could also be done in pursuit of reduction of crime. And to give it an umbrella, as you know, as a number of state legislatures have done, is just to specify this is a broad idea.
But that's why we don't just say, well, we're just gonna do public safety. That's what we want to focus on in our sentencing. That's why we don't say that. We include all these other aspects that we're now trying to use as the definition of public safety. I guess is what I'm trying to say. Because we're really trying to do a number of things throughout in our sentencing.
Mm-hmm.
We're trying to set this offender on the right track and to give him an opportunity to be a good citizen upon the completion of whatever sentence is imposed,
Mm-hmm.
which is the rehabilitation, which is the deterrence,
Mm-hmm.
which is the punishment, which leads to public safety.
Mm-hmm. No, I think the proportionality of a sentence is something different than public safety. The guidelines give us two banners or two major headings for the purposes of the guidelines: public safety and proportionality. And so public safety doesn't comprehend all of it, but those are the two major headings that the guidelines set forth without much definition, which may be the right way to go. Maybe any attempt to fill in what the definitions are is, I don't know, too controversial or contested or unnecessary. But if we believe there are meaningful numbers of people who don't kind of think through it this way, then there may be an advantage to putting some definitional, some sort of concept defining language into the text itself.
Okay, I think I see what you're saying. You're taking the statement of, and this is the first time kind of going through this and looking at this.
Right.
So you're taking the statement of purpose and principles.
Mm-hmm.
And
Right. In
now
guideline 1A.
right, I see. So when we read that, it's to public safety, reduce sentencing disparity, and ensure proportionality.
Mm-hmm.
Okay.
I'm-
Maybe instead of defining just the one term, that we add some of these other terms into the basic statement and in the first paragraph, that there's these other considerations for public safety, but rather than trying to define public safety, it includes the goal of rehabilitation. It includes the goal of deterrence. It includes an aspect of punishment.
Mm-hmm. Right, and I'm very attracted to adding some language about our fundamental understanding of proportionality. Maybe, an additional paragraph below this.
Will we let Commissioner Keefe get in here real quick? Because I know you had a thought.
I was just gonna say, I think having the rubrics of the sentencing guidelines is one thing, and then talking about the vision about how to apply them, I think does have value. And even thinking about one of the quotes from today about the person that stole $10 and whether a sentence departure was valuable or not. I think thinking about like the demographics of the person, what area they're from, punishment versus rehabilitation, and having a statement that talks about what really is the purpose of it feels valuable. To your point that some people might need to see something.
Mhm.
in how they-
Well, I know first-year law students need to see something like this.
That makes sense.
Or think about, you know.
Okay, well, I think we're getting shorter on time, so I think you've been given some feedback today that will be useful for a
Mhm.
next draft. So we can definitely work on it a little bit and maybe bring that back to the August meeting. Any other comments real quick before we leave this one?
We had any thoughts about,
Commissioner
sorry,
Locke?
we had any thoughts about sort of rewording this or reframing this? Could we just send that to Nate or in advance so that that can be part of like the consideration? Because I just want to get some more thought to it because I think that there's some interesting nuggets in here, but how it's framed up right now, it gives me a little bit of heartburn. So I'm
That
just
would
trying
be
to figure
very
out how
helpful.
I can,
Very helpful to me.
get information forwarded to somebody. Would that go to Nate or?
That sound good?
Sure.
Yeah, Nate, send it to Nate, Commissioner Larkin.
And so the goal of this exercise is to include a definition of public safety, since that's our primary purpose. That's a question.
I think that's what's being suggested.
Okay.
Yeah.
Right, I mean, I mean, to me, it might be useful to explore a definition of proportionality as well, because those are, you know, two terms I'm not sure it's self-evident what's meant by those terms, and yet they're big banner headlines in the guidelines.
Yeah, I mean, I wouldn't be opposed to seeing something along those lines as well and discussing it. I mean, for August, we'll have all the stuff in advance, so you wouldn't be like seeing it for the first time when in the meeting that day. So maybe we could ask for that as well. Yeah, Commissioner Larkin.
And just practically speaking, how does including those types of definitions impact a system where you look at a criminal history, you look at an offense severity, and you go to a box and you're told that's what you must do?
I think for us, it gives us some principles to ground how we construct the guidelines. For the court, I would assume that they're having to think about that as they're exercising discretion within, within the guidelines and within the rules that allow departure. That's
Yeah.
what I would put out
Yeah,
there.
also, as a departure consideration, I think a judge should be thinking of, well, what's the general context of what the guidelines are trying to do as applied to a, potential departure decision.
Commissioner Larkin.
So then a judge would say, well, substantial and compelling circumstances, and then cite something in this list?
Well, I think there'd have to be a factual predicate in the case. I mean, we saw in Julia's presentation a lot of very fact-specific reasons that the lawyers give for treating a case as less serious than another. And you could probably translate a lot of that either in terms of public safety or proportionality. In many of the examples Julia gave, proportionality when there's been no injury, right? May be different than proportionality when there is a substantial injury.
So just an observation, I think what the chair said, this language is really for us as a decision-making body to guide our decisions. I'm pretty darn sure most judges have never read purposes and definitions section of the guidelines and don't think about it when they're sentencing. So if what you're really trying to do here is encompass the factors that might support a departure, I think we should as I suggested earlier, identify what those are and see about writing those into the departure grounds, because I just don't know that this is the area that's going to make a difference in what happens in sentencing in court. I could be wrong, but I'll defer to Judge Knudsen on that, but it seems to me this is language to guide us more than practitioners. And if it's meant to guide practitioners in the bench, then it might be better to put this in the departure section.
Okay. I mean, I'll just say, I mean, it's also being given to us out of context, so not really with all of the other statements of purposes and principles. So that might make it a little hard to think about where it is in the guidelines, but I would say that that section is, you know, essentially our philosophy. That's our philosophy statement about how the guidelines, what their role is in sentencing in Minnesota. So it's not bad to adjust that. We're doing a comprehensive review, so it hasn't really been adjusted. It's been reorganized stylistically, but not the words haven't been changed so much over time. So it's a good time to take a look at it.
And I agree with that this is the guiding philosophy, but all I'm saying is
Yeah,
at the end of the day, when it comes to sentencing, you're still looking at a number in a box, regardless of the guiding philosophy, unless you're proposing that a judge can say, well, consistent with the guiding philosophy, I'm going to do a departure, even though this isn't a recognized departure ground, or even though it might be inconsistent with case law. I'm just struggling with how this gets used. And if that's how you want it to be used, I'm just suggesting that you need to address it somewhere else. I'm not saying this
Okay.
isn't good. I'm just trying to identify how this works in practice.
All right, let's go ahead. We'll have to, since we're really at time, we should close it down. My question would be, I think we have like 15 more minutes of content. Would people be willing to go with that, or would you prefer that we push stuff and move on to the public comment stage? I can do either today. I'm not hearing objections, so I'm going to take your 15 minutes. All right. All right. So I'm gonna ask Nate to tell me how to share my screen. The next item on the agenda is just talking a little bit more about the announced closure of Stillwater facility. I think I found it. There we go.
Yeah.
Is it going to come up?
It's up.
Is it? Oh, okay. Okay, it just wasn't there. Okay. Okay. So I just wanted to let you know, for anyone, in case anyone missed it, when the public safety bill was enacted, part of the one thing that was included in the public safety bill was that the Department of Corrections is required to move towards closure of the Stillwater Correctional Facility. It's one of our oldest in the state. There are a number of maintenance issues, livability issues, a lot of reasons why it's no longer a facility that really should remain open. So under the law, the DOC is supposed to move towards full closure within the next 4 years. So I just wanted to tell you a little bit about that, just make sure that everybody was on the same page, especially as the Sentencing Guidelines Commission, who has to be cognizant of bed space as we are making decisions. We should know that this is happening. I'm showing you the Department of Corrections page, just in case you want to visit this frequently so that you can get updates. If you look under the About section of the Commission's website, we do have this MCF Stillwater phased closure page. We'll be updating this on a regular basis. But basically what the phased closure means is that we will be working towards closure in 2 phases over the next year. The first phase involves reducing the current population. We have about a little over 1,000 beds at MCF Stillwater. We'll be reducing that, probably by about half over a period of months. And so right now, what we're doing, right now, we have committees stood up to really think through how would we achieve that? What would be the programming and types of operations that would remain at Stillwater? Where would the individuals who might be moved out of that facility go within our system? We do have open beds in other facilities, so where would they go? And really, what would it look like for those remaining at Stillwater for the next 4 years? Beyond that, then after we do that initial reduction, then we will be working on a couple of studies to really figure out what the full closure of the facility looks like. Part of that, it is a historic site, so part of that is actually taking that into account and figuring out what the potential uses are of that space and what does it take to actually decommission a prison that is also designated as a historic site. So there's a couple of hoops to jump through there that have nothing to do with our operations at DOC. But we're also really trying to think, holistically across our system about what makes the most sense in closing that facility. And what we do, what that's going to mean for the system as a whole moving forward. On this page at the very bottom, you'll see that we are posting communications. So we have our initial press release there. We have a memo that we issued to friends and family of those who are incarcerated. There's been 2 memos issued to friends and family so far, and that's essentially a memo that any member of the public might be interested in reading. So as we have new information that we're able to share, we will be communicating with our staff, with the incarcerated individuals, and with the public in general. And those the public communications will be posted here on the website. So you can always come to the website to get more information about that. I wish I could tell you more about the exact plan today, but we're still in the process of figuring that all out. As soon as we do have a plan, though, we will be communicating that publicly. So rest assured that every step of the way, our goal is to be transparent and to provide information. And so as the DOC rep on this committee, I'll always be here to talk too about the impacts on the system. And of course, that's the lens that I always look at. The decisions that we make here is what is the bed impact of that, as well as public safety impact, and which offenses really should we be using our correctional resources for, and which ones could we address in other ways. So I just wanted to make sure that you all knew that we had that information out there, that you were aware of the closure. I can answer any questions if people have questions today. Director Wrights has a question.
So Madam Chair, just looking at the July 1st, 2024 numbers, this looks like an 18% reduction in bed capacity for the adult male population. And by my math, there's like a 268 bed deficit after this goes away, assuming the July 1st, 2024 numbers stay put. Is the DOC planning on building housing for those 268 folks, or housing them in the jails, or has there been thought about that?
Yeah, so that's literally what that second phase is all about, is understanding what our options are and what we can do, what we can feasibly do moving forward, knowing that bed capacity is limited right now, and that we need to be able to have the beds available for those most serious offenses. So I don't have plans today. I don't have any answers to that today, but that's definitely what we'll be working on over the next couple of years. And I think I saw I feel like I saw Commissioner Reeves first. Yeah, and then Commissioner Larkin.
Thank you, Madam Chair. So the friends and family memo, how is that being distributed? Are people supposed to come onto the website to see what it says, or are they actually sending it to friends and family?
That is such a good question, and I should have gotten the answer to that before I came today, but I will find out and I'll let you know. Yeah. Commissioner Larkin.
I thought I'd heard on the news or press reports that no one would be released early because of this and that there were adequate beds to move people to other facilities. Is that the case?
Yeah, that's correct. No one will be released early as a result. So like, we're not going to come up with any new early release programs like we did in COVID to try to reduce our prison population quickly. Nobody will be released early. You know, part of it is attrition, like many of the individuals who are currently there will be serving their full sentences and will be releasing to the public soon, or releasing to the community soon. So yes, right now we do have the beds to absorb the population. We just have to plan for future. Yeah, exactly.
And is
Commissioner Larkin.
St. Cloud closing as well?
No, there's no current plans to close St. Cloud.
I read that? I thought I read that. My bad.
No, I mean, what you might have read is that St. Cloud has some of the same deferred maintenance issues and that Stillwater did, and it's actually, you know, similarly old. It's our second, the other oldest prison in Minnesota. It does serve a unique intake function for us right now. So it's definitely not something that we've put on the table for elimination, but long-term, the state is definitely going to have to look at, what are the options, given that facility is also just as old and has many of the same types of deferred maintenance issues that Stillwater does. Anything else? Okay, that's it for me. Then Executive Director report.
Thank you, Madam Chair. Before I jump into that, members of the public, in a few moments, we're going to have an opportunity for you to make comments if you'd like. So you should all be able to raise your hands. So if you would like to make a comment, please raise your hand at this time, and we'll take your comment afterwards. So I'm going to start by talking about document number 8A. Just breeze through that really by bullet points. One is our agency is funded for the next 2 years. Yay. So we are not subject to the layoff notices that you've been hearing about in the news. Two, we talked about MCF Stillwater. Three, there's going to be some really eye-popping penalty assessments that are required at sentencing, although they're waivable for if certain factors are met, but really huge dollar values that judges are required to assess. Fourth is the task force on mandatory minimum sentences was approved. I am going to be on that, and I hope that Dr. Laskronsky can present some of that information to that task force. Fifth, the treatment of water pipe fluid modified. I was the original water bong prosecutor, so I'm hoping that this bill finally kills that dark chapter of my life.
Was that Judge Neville?
Might have been.
I think it was.
Yeah. Anyway, and then the statute of limitations for arson was extended. But I'd like to just spend a minute talking about B, and that is really just information about a past action that the commission took to repeal medical cannabis. We thought that repeal, and that's because it's been sort of replaced by a new structure in the cannabis bill. But we thought that repeal has already taken place, so we were going to change it without asking further permission from you in the August 1st edition of the sentencing guidelines. It's recently come to our attention that there may have been a session law that we weren't tracking that amended the effective date of that session law. So it may be that this isn't quite as dead as we thought it was. So stay tuned on this, but this may not be something that comes out in the August 1st edition. It may have to be delayed till the next year's edition. And then if I can just jump into the executive director's report, I'm just going to do this chronologically. June 12th. Judicial Council meets and they have the appointment of our district court representative on their agenda. June 28th, that's your deadline for submitting per diem. I should have said June 23rd. That's your deadline for submitting offense group 3. June 28th, if you're a public member and you haven't been submitting your per diem requests, please do that for this fiscal year by June 28th. Same deadline, if you have mileage that you'd like to claim, please submit that by June 28th so we can get that in this fiscal year when we close our books. July 17th, that's the public hearing date. You're not required to come to that. There's no quorum that's required unless that turns into a meeting and the chair let us know. At one point, the chair talked about possibly having a public hearing followed by a meeting, but no decisions have been made on that. As far as I know, the July 24th is the meeting date. So it's 1 week after the public hearing. And by the way, you're welcome to come to the public hearing. I'm not trying to discourage you, but it's just it's the rare meeting where we don't require a quorum. July 24th, we definitely require a quorum because that's when you're going to be taking final action on the guidelines modifications that you just voted on. August 11th and 12th, those are the dates of the National Association of Sentencing Commissions annual conference. It's going to be pretty conveniently near in Madison, Wisconsin. It looks like we're going to be taking a minivan and kind of filling it up. So we are going to be inviting some commission members. Typically, I start with the people who have either never been invited or been invited longest to go. So we'll have, looks like 2 staff members and a 3rd staff member that Robina's paying for in the van. So there should be room for 3 more commission members in that van. So after 11th and 12th, so we'll be coming back on the evening of the 12th, going to bed, waking up and coming here for our all-day commission meeting on August 13th. So please, they should already have that on your calendar, but that is an all-day commission meeting. And Madam Chair, that concludes my executive director's report.
Thank you. Any questions about any of those items? All right, then let's see if is there anyone who would like to present public comment today?
Madam Chair, I just call the commission's attention to the public comment that is in the meeting materials. It was a pretty interesting advocacy for using the same rule for prior offenses that's used in Minnesota statute 609-1095, which is to say that the offense date must, that the prior conviction must have occurred before the current offense date in order for it to be counted as a prior. And the author of the letter would like the commission to use the same principle in criminal history score calculation. Madam Chair, there are no members of the public online who have raised their hands.
All right. Well, I think that concludes our agenda for today. Is this your last meeting though?
This is my
Knudsen?
last meeting, and it has just been my privilege to serve on the Minnesota Sentencing Guidelines Commission, to get the wealth of the background, the depth of the discussion, the seriousness and the intentionality of every single member that has been a member during my time on the commission is just it should give the public, and it certainly gave me a great sense of confidence on how the guidelines are constructed, the modifications that happen. And I mean, you can see from today's agenda, all the work that goes into just the passage of just a few criminal bills, and to give some life and some direction and some structure to what the legislature passes. So it's been again, like I said, a privilege to serve with each and every single one of you, and I wish the commission the best in the future as we go forward. I'm excited to see what reforms and changes and modifications come out, and good luck. Thanks for your patience with me.
Well, we're going to miss you. I mean, the steering committee is forcing you to come to one more meeting before the end of June, but commission wise, we're definitely going to miss you and really appreciate the practical experience from the bench that you've brought to this commission. It really, in my opinion, really illuminates some of our discussions and gives us exactly what we need to think about. So I really appreciate I'm really proud to have served with you, and I really appreciate the perspectives that you've brought.
Thank you.
Madam Chair, on behalf of the agency, I just want to say that it's an oversight on my part that we do not have a plaque to, I think this date kind of snuck up on me. and-
No more plaques.
Got the money
My
for
wife
plaques.
has already said nothing is coming home.
I don't know if you're gonna get him to not make a plaque.
Keep your car.
Cabin? I don't know.
Yeah. Wall decoration for your cabin. I like that. All right. Any other comments?
You're okay.
All right. Well, unless there's an objection, this meeting is adjourned. I will see you all in July. Thank you.